Welcome to the 2020 Public Health Law Virtual Summit. We have two presentations in this session, and each presentation will be followed by its own individual Q&A. Use the chat feature to submit your question, and if you encounter any technical difficulties during the summit, go to the navigation menu and select the Need Help button. Now I'll turn things over to our first speakers, Denise and Peter.
Great, thanks a lot. Thanks a lot, Charles. Welcome, everybody. Charles, could you go to my first slide, please? I'm Denise Chrysler. I'm director of the Mid-States region of the Network for Public Health. I've been in this position for 10 years. Previously, I spent over 27 years working for the state of Michigan, and I provided legal representation and counsel to the state health department. And this included the whole host of public health issues, including emergency preparedness and response, and certainly all of the work I did over all of those years and feeling like we were doing such great preparation feels like it's certainly inadequate, and this is definitely a time of facing the most complex issues that I have ever seen in all of these years of public health practices. As you know, legal issues are often complex in routine times, and even more so now during this public health emergency. Next slide, please, Charles. So state and local public health officials, and additionally governors and governing entities, all who make decisions during this pandemic, have a difficult time as it is, but it's important that decisions be made based on timely and reliable data and science. However, here we have, as we know, a novel situation, and information is absent. It's also a moving target, and as Peter will speak more to, is at many times has been politicized. So just answers to the basics in order to make decisions such as who is infected, who is infectious, and how that's changed over time and how we view that decision. How does this disease spread? What control measures work? Who's recovered, who has died, all the issues we've had with data and what data we can trust and what that data says, who is immune from reinfection, and what resources do we have, who has them, and how do we get more resources. Next slide, please. So Peter and I often use, anybody who's gone to a presentation that Peter and I have spoken at, we usually use just 3 questions in looking at exercise of authority. First, a legal question? Do I have authority? Must I? A legal question. Does law leave me no choice? And should I? Policy. This is a policy and ethics question. How should I exercise my discretion? Next slide, please. And often when Peter and I speak, we're often speaking about public health officials, be it state health officials or local health officials. And we speak about them now, but often they are now making recommendations, for example, to their governor. So with the can I, using law to protect the public's health, do I have the authority? Do I have power? What is the scope of my power? What interventions can I use? And who else has the power? Who else has the power has been a big issue during COVID-19, simply because in all of my years of public health practice, I have never seen the kind of involvement we have had from a governor's level. And so what does this mean for power when your governor acts? What does that mean for the state health official? What does that mean for the local health official? And what does that mean for a governing body of a local governmental entity? And this varies so much state to state, having to look at how the powers work together, and then currently different laws that are being passed or court decisions with regard to preemption and how exercise of power by one entity affects exercise of power for another entity. Next slide, please. So the must die, using, does law leave me no choice? So whether I'm mandated to act or whether I'm mandated to act in a particular fashion comes up. While public health has power and responsibility to protect the public from disease and other health threats, generally the agency has a great deal of discretion in determining how it fulfills its obligation. Next slide, please. So the last of the questions is, should I, if I have the authority to act and I'm not mandated to act in a certain way based on my discretionary power, should I act? How should I act? When should I act? And what should I consider in exercising my discretion? Generally, health officials have broad and flexible authority to protect the public and must use their professional judgment to act or not to act and what action to take. So the should I is usually where health officials live. Next slide, please. Often there's no right answers, there's only choices, and often public officials must choose amongst flawed decisions. There's trade-offs and there's competing principles. The choice should make sense, reflect ethical principles, and the basis should be documented. So first, discretionary power must be used reasonably and impartially. The legal standard for reviewing the use of discretion is whether an action or a failure to act is reasonable or whether it is arbitrary or capricious. And arbitrary typically means not considered, ignores the facts, is whimsical. Capricious means impulsive and unpredictable. So you need to consider the facts, principles, and laws, and especially be able to articulate the basis for the decision and show, if you are the public official or the health official, that you considered and weighed alternative. And always remember that doing nothing is doing something. So this should be a conscious choice. And with that, I will now pass things over to Peter.
Well, Peter, I think you're muted.
Let's try that again. Thank you, Charles. I'm Peter Jacobson, co-director and principal investigator of the Mid-States region of the Network for Public Health Law and professor emeritus of health law and policy at the University of Michigan School of Public Health. What Denise and I did for in writing the chapter on executive decision-making using the template Denise just outlined is to take a look at how some states actually implemented their emergency declarations. So emergency declarations provide maximum flexibility to the governor for the protection of the public's health, often time limited, though not always. In fact, Michigan has both a time-limited emergency statute and one that is unlimited. But many of these emergency declarations lack criteria and guidance, so you see wide variation in how they're constructed across states, some of which we'll get into in a minute. Next slide, please. We have to look at what the legal authority is. Look first, at least, at the legal authority of the declarations that have been issued. And the first, as I suggested, are these specific acts granting emergency powers. But many state public health codes also provide general authority for state and local health departments to act in emergency situations. Though, as Denise suggested, the nature of this pandemic is such that it really makes more sense to have authority reside with the governor for a variety of reasons we can get to during the chat. The one difference, some of this is clearly overlap between the emergency declarations and the public health codes, but they're not the same. They have very different limitations In particular, the state public health codes impose very specific procedural safeguards that aren't necessarily engaged in the Emergency Powers Act. In any event, you can map easily the differences in any given state between the two legal authorities. Next slide, please. But all of this operates within a political context. The governor especially needs to be concerned about balancing the economic and scientific aspects of it. In particular, the disease prevention with economic harms. We're seeing that played out in a lot of the litigation, and certainly in contests between legislatures of one party and governors of another. Again, as we'll see, the split governance between the two presents significant separation of powers issues. And we also know that there's an active resistance to mask orders, to stay-at-home orders, to limiting public groups to 50 people or 100 people during the protests, Black Lives Matter protests. We had thousands during some of the Trump rallies. Now you're getting thousands. Also very difficult to enforce. And one consequence of this resistance that public health officials and elected officials need to take into account is then the attacks on public health officials. It's serious. In my view, the actions that health officials take and governors take need to consider the potential for further attacks on public health. Next slide, please. There are also judicial constraints, as we saw recently in the Pennsylvania case of Butler versus Wolf. Courts are not simply going to allow unlimited duration of emergency orders that don't contain in the legislative authority some limits, because the emergency declarations do, at least to some extent, infringe on fundamental rights. First Amendment rights of free speech, freedom of association, 14th Amendment rights of due process, and personal freedoms issues. You can also make, businesses have made arguments under the 5th Amendment for takings without just compensation if these acts go on too long. And as I mentioned, you have the disputes between the governors and legislatures where party control is split. Next slide, please. So we go back to Denise's template, and with regard to the emergency declarations, we first asked for, in terms of executive decision-making under COVID-19, must I act? No. Can I act? Yes. Should I act is inherently a discretionary policy determination. So any state has to ask, when should I declare an emergency? What should I include? Masks, stay at home, essential businesses, non-essential businesses. Again, there are no criteria for what to include, what duration the orders should stay in place, how they should be ended, etc. So when to end an emergency order is an important issue. Underlying all of this is, what role does science play? Again, there are no criteria. In Michigan, the executive orders contain general statements of the threat to the public health from the spread of the pandemic, the need to mandate masks, the need to stay at home, but there's not a clear and consistent recitation of the scientific nature of the spread of COVID-19. And I'll come back to that talking about recommendations. It is, and I want to keep making this point, it's a balance of science, economics, and politics. What we've concluded in our work on the chapter is that it's really science through a political lens. There's no question that science, public health science, underlies the emergency orders. But there's also no question that the science is filtered through a political lens. As we discussed in our Q&A session yesterday, it's important for us to remember that all public health is both scientifically based and a political entity. Next slide, please. So we looked at 8 states, non-random. Make no pretense that this is random or comprehensive. And we made some arbitrary decisions based on political party control. We wanted to get a balance of both all Republicans, all Democrats, and a mix. So you can see we have Alabama, Arizona, both Republican, Colorado, Democratic, Florida, Republican, Maine, Democratic. Michigan and Wisconsin are the 2 that we have with Democratic governors and Republican state legislatures. We couldn't find any where you have a Republican governor and a Democratic legislature that would have made a difference in the analysis. In Texas, all Republican. Part of the reason we selected this, aside from party control, was they had very different disease outbreak statistics. And in the chart we have that I couldn't figure out how to put on the slide, in the chapter you can see how the spread of the disease changed from early May, June, when most of these declarations were put in place, some as early as April, and the end of July when we finished the article. Next slide, please. Okay, so the 4 Republican states imposed no initial requirements, but instead encouraged compliance with CDC guidelines. And really, there wasn't much enforcement about that either. The remaining states required masks, social distancing, and for the most part, phased reopening. As I alluded to before, it's pretty hard to assess and disentangle the science from the political and the economic considerations. From reading the emergency declarations, it really looked like Maine, Colorado, and Wisconsin relied very heavily on the public health science to guide the initial order and reopening. Michigan relied very heavily on those data in determining when to reopen. Next slide, please. We also found, somewhat surprisingly and really discouragingly, that equity played a minimal role. I think really only Wisconsin and to some extent Michigan even talked about vulnerable populations and made almost no references to data collection on the basis of race, ethnicity, and vulnerable status. In fairness to the states, it wasn't apparent up front that the pandemic would take such an enormous toll on Black and brown communities. So going forward, that's going to be another important recommendation. For the reopening, and I have about a minute and a half left, the reopening was a function of disease spikes. So some of the early relaxers, Alabama, Texas, and Arizona, saw spikes after reopening and then imposed new restrictions. Whereas Florida reopened very quickly and still imposed minimal restrictions. And the late reopeners saw limited spikes. Next slide, please. Okay, so what do we make of this? we see wide variation, which is, of course, a feature of federalism. My own bias is that a national approach would have been preferable. We didn't see that. We saw a lot of confusion. We continue to see a lot of confusion at the national level. To belabor the point, governors are making political and economic decisions. That's what's driving the process. Yes, the underlying public health is key, but they're political decisions. The 4 early reopenings show the limits of public health in shaping policy. The reopenings were clearly premature, and the subsequent spikes demonstrate that. But I do think that the science was instrumental in the initial declarations and decisions to retrench. So again, Public Health Rule Political Alliance. Last slide very quickly, please. Our recommendations are that the declarations must include the specific epidemiological data supporting the order, the explanation of why the order is necessary, why the order is consistent with personal freedoms. I didn't get to talk about that. I think that's really important. That message needs to be sent. Communications with the public must be transparent. Governors must protect public health officials and should instruct public health officials to incorporate equity considerations, including data collection and analysis on racial and ethnic disparities. Thank you very much. Happy to take any questions, Charles.
Yes, thank you, Denise and Peter, for that great presentation. I just told people that they can submit questions via chat, so we'll just give it a minute to see if anyone has any.
Well, I know someone had raised his hand. I saw that, but I didn't get the name. Was it Charles Wilson? Something?
Yeah, I'm not seeing it. If you did raise your hand, please submit questions via the chat.
In the meantime, Isla had raised a question.
Yep.
Can I speak to what a national approach could or should have included? I think very clearly a mask requirement, doing more to say that the masks are needed not just for your protection, but for the protection of fellow citizens, and really trying to depoliticize as much as possible. Really trying to present the science, the case. We're grown-ups. If there's a potential public health threat, not trying to downplay it is not a good strategy. And I think the governors, on the other hand, did a much better job of trying to say, in many cases, this is serious. You need to have social distancing. Specifically to Isla's point, I would argue that the federal government and should clearly have provided focus on the production and distribution of masks, protective equipment, ventilators, and the like, and also the messaging of this is not an intrusion into your civil liberties. This is for our protection. So I don't want to belabor this question in case there are others. Julia's question is, can we point to a U.S. jurisdiction or country that's made nearly optimal decisions? Probably New Zealand is I think by consensus, the global example where they didn't make political decisions. South Korea also shut down early, and in terms of the U.S., I'm wondering, I'm blanking honestly. I think Rhode Island was one of the states that did well. Ohio Ohio is probably the best example where Governor DeWine took it seriously and really made scientific decisions, not political decisions. But even in Ohio, the state health officer resigned because of the attacks that she was facing. So, I mean, that's the problem. This became such a politically divisive issue over wearing masks, social distancing, that even in a state that handled it well, you saw problems.
Is there I'm sorry, question in the chat box? If there isn't, I have a question of Peter.
No.
There is.
Okay, Peter, this
Go
is what's
ahead.
been bothering me. We always say doing nothing is doing something. So
Right.
make it a conscious choice. Well, the governors have to balance common good and individual liberties. So the governors, at least initially, who did something, they were the ones who were making a choice to impose a number of restrictions
Right.
to help prevent the spread of disease. And so those were the ones who ended up being challenged either politically or some of them in court. Well, the governors who did nothing, you must, as far as must you act, it's pretty rare that you must act, and mandamus to make you act is pretty narrow. So the governors who did nothing, they were choosing individual liberties over the common
Yes.
good. And
Right.
I'm just trying so I'm trying to make sense out of that in my mind. And
Well,
with your
I
professorial
I think it's
knowledge.
I think it's a great point, but 4 of them had to retrench. Three of them retrenched: Arizona, Texas, and one other, Alabama. Alabama. Florida did not. And you can see the disparity of just overemphasizing the personal freedoms during the pandemic. There were decisions that proved not to be correct. Herd immunity is not, I think, a viable policy alternative, as we saw in Sweden. So you have a question about what the authority courts would have to uphold a national mask order. I don't see any. I don't think you could have a national mask order easily, which also someone raised the eviction question regulation. It's not clear to me that eviction, CDC's eviction moratorium will be upheld. I'll defer to the real lawyers on the call or my public health law colleagues on both of those. But I'm dubious that there's authority to uphold the a national mask order would have to be hortatory, would be something that the government encourages the population to do. And same on the evictions. So then I think the evictions is probably a closer case but I don't know. And then there's a really good comment from Ruth saying on the last recommendation that the public health officials are maybe the ones advocating to the governors to include racial ethnic data to track disparities. It's a good point, and we can only hope so. And I'm not seeing any other questions.
And I think that's a great place to stop right there. Thank you both, Peter and Denise, for a wonderful presentation. And I'm going to pass things off now to Isla and Heather.
Okay, thank you. So we're really excited to be here. See if I can get this up and going. Quick. Okay. Okay. So jag är Heather Tanena, jag är Denise. On my mother's side, I'm Bilagana. On my father's side, my clans are Kiani, that's a towering house, and the Blackstreak Woods people. And I'm a research assistant professor at the University of Utah, S.J. Quinney College of Law. And then I also work with the training team at Johns Hopkins, their Center for American Indian Health. And Isla, for the remaining half hour here, we're going to talk about what's going on in Indian country. And, over a presentation there, upholding tribal sovereignty and promoting tribal public health capacity during the pandemic. And I think kind of a real silver lining that's come out of the pandemic is all of the attention that tribal communities have received. It's really unfortunate that it took a pandemic to get that attention, but it's highlighted some of the real disparities and challenges that tribes face. And when we're dealing with public health issues, I think we all know, right, it's very multifaceted. A lot of factors go into understanding a public health problem, and we really need to understand those factors when we're trying to propose solutions and implement them. And two of the factors that are really of paramount importance when we're dealing with tribal health and communities is history and the law. And so my portion, I'm going to spend a few minutes before Isla gets into some of the more practical and on the ground applications. But I'm going to cover some basic history and legal considerations, right? This is the context that we're dealing with when we're trying to address public health issues in tribal communities. So take us back to 5th grade, if we remember just some really basic US history principles, right? Because again, American Indian, Alaska Native history, that is US history at its core. And we started off, right, under the Articles of Confederation with states having the primary authority. And then when the US Constitution went into place, that's when the federal government started to take some control. And we have these very specific clauses that give the federal government the authority to interact and regulate with tribes. And then, right, because of our supremacy clause, really it's created a situation where the federal government is the entity that's going to have that government to government relationship with tribes and has set them up as a sovereign nation. And moving on in our history line, I'll talk a little bit more about this on the next slide, but there's this principle of doctrine of discovery that again established tribes as sovereign nations and started to set up the relationship that tribes would have with the federal government and to some extent with states. And then I just think it's, a lot of people don't realize, because tribal nations predated kind of establishment of our country, the Bill of Rights didn't originally apply to tribes. And so the Indian Civil Rights Act in '68 applied many of those protections, but not all of them. So again, right, a lot of factors are influencing public health. And Isla's published a great paper for those who are interested in reading up on this a little bit more about how federal Indian policy is a determinant of health for our tribal communities. And for those who aren't familiar, these are the different time periods or eras of federal action towards tribes. And to some extent, their titles are a little self-explanatory, but I'm going to run through those briefly. So again, doctrine of discovery. John Marshall was the chief judge at the time, and so we call these 3 series of cases the Marshall Trilogy. And that's where the court decided that tribes and indigenous people in this country, they were discovered, they were not conquered, and because of that, they retained some inherent powers to govern themselves, some sovereignty. And through those 3 cases, we get some really key principles: tribal sovereignty, but domestic dependent nations, that even though tribes have some sovereignty, they are still reliant on the federal government and dependent upon the federal government, and that's created these trust responsibilities. You'll hear the relationship being like a guardian to a ward, right? The trustee responsibilities. And so that initial, by going with discovered versus conquered, it has set up the foundations of Indian law and how tribes, what powers they have, and how they are governed. And then moving on, right, there's a whole era of treaty making between the federal government and tribes, right? A lot of those treaties have rights that tribes are entitled to uphold, right? So those who may have read about the McGirt case, that really tied into what the tribe's treaty right was and what they bargained for when they were relocated out west, which was part of the Indian removal and reservation era, right? A lot of these actions by the federal government were often, in principle, it was intended to be for the benefit of Native people. But if you look a little bit behind the actions, it was really, moving tribes westward because they were on land that white settlers wanted. And so that was really the motivating factor behind the removal, reservation, and allotment eras, that if we, let's move the Native people a little bit more westward, get some more prime lands for the white settlers. But if we can make Native people be farmers and Christians, well, then they can be a part of the broader US and everything will be okay. Surprise, surprise, that those policies were not beneficial and actually resulted in quite a bit of harm. And again, Indian reorganization era was interesting, I think, because, again, well-intended. The federal government encouraged tribes to formally establish their governmental entities, to adopt their own constitutions, but they wanted tribes to do that in kind of like the white man's way, to follow their model rather than to determine what was best and culturally appropriate for their own community. And then there was a total flip with the termination and relocation era, where many tribes lost their status as tribal nations. And then a flip again where we currently are in the self-determination era, where tribes, this is really heralded as a really great era because tribes can take control of their future, right? They can take control of their programs, structure their own governmental bodies the way that fits in with their traditions, their culture, run programs the way that they think is best for their people. So the big emphasis I want to have you go away with, if you're not familiar with this area of law and this history, is that those eras and the actions of the federal government, even though they were in the past and in some situations, right, hundreds of years ago, they still have lasting impact today on tribal communities that affect the health and well-being of Native people. And these are some examples of actions that were taken by the federal government that have resulted in historical trauma that lives today, right? Again, every tribe is unique, but we kind of share many of these themes. So the forced relocation wasn't just the Trail of Tears or the long walk that the Cherokee Nation went through, or the Navajo Nation. Many tribes were forced to walk hundreds of miles and leave their homelands and live somewhere else, just everything left behind. Their homes, everything they knew, their livestock, their livelihoods. And then the boarding school eras, again, another action by the federal government that was well-intended. Let's educate our Native children, but the way they did it resulted in severe trauma and harm. To remove children without any forewarning, any discussion with that community, families didn't know if they would see their children again. The kids didn't know if they would see their family again. Very, very traumatizing. Usually I'd share many more personal stories that I have. Many Native people talk to you about a relative that they know who went through that boarding experience and the way that it's impacted their family. So I encourage you, if you work with tribal communities, right, listen to these stories, because they have a really strong impact and show the continuing harm that these actions have had. Again, uranium mining, right? We just had New Mexico do a study. Navajo babies today are being born with uranium in their blood. So mines that supposedly were long closed and cleaned up, there's continuing exposure and harm happening. And just real quick on the landscape, it's changed, right? We started out with tribal control over the lands, and anyone who was in their lands was really absolute, and states were very limited on what they could do. It's been whittled down. You can see this is, I'm in Utah, so those are examples of Utah. The orange on that, the state map there, those are the tribal lands today. So a lot smaller states are encroaching on tribal powers. The federal government has limited tribal jurisdiction over non-Indians, even though they're living within their community. We'll touch on that a little bit more. But last takeaway, tribes are still here. Native people, we are extremely resilient, and there are some really positive things that tribes are able to do. And that's, again, through their tribal sovereignty. They still have today this inherent authority to protect and promote the health of their citizens. And that is what Isla will go into a little bit more of what they've been pulling on to protect their communities when COVID-19 came through and really had a very devastating effect. I will hand it off there.
Thank you so much, Heather, for that incredibly important primer. Folks, my name is Isla Haas. I am a public health attorney by training and a professor that researches and teaches at the intersection of Indian law and health law. I am non-native, but the greatest privilege of my life has being able to learn from tribes and American Indian Alaska Native communities on public health law issues. And as Heather already said, it is so devastating that our work is so relevant right now. With the COVID-19 pandemic, we've seen a variety of health inequities that have been getting a lot of media attention. We know that American Indians, Alaska Natives are getting COVID-19 infections at higher rates than other groups in many states, and they're seeing worse health outcomes than other groups in certain locations. I also want to take a step and emphasize a lot of the tribal resiliencies. Lummi Nation, for example, in early 2020 began building a field hospital, anticipating even before many of state and local governments and even the federal government that there was going to be a need for quick and thorough government response to the pandemic. We have seen CARES Act funding being used to build new health facilities, provide distributions to citizens, community gardens, and while we have also heard a lot about Navajo Nation and the Mississippi Band of Choctaw Indians experiencing incredibly high rates, we don't talk enough about the fact that the Navajo Nation has seen testing rates at higher rates than the national average, that we have seen some tribes doing complete testing of every single one of their members. And that is, and not even to mention the fact that tribes have been relying on culture, community, and traditions to respond to the crisis in a way that has served their communities very well. But we do have to talk about how law is a barrier to health, and it is no greater example to that than in the context of tribal public health. So starting with federal law, the federal government has treaty constitutional obligations, because treaties are considered the supreme law of the land, and trust responsibility requirements that have been codified in statute, reaffirmed in case law and regulations to provide health care to American Indians, Alaska Natives. This is required by law, and it is beyond just a fiduciary responsibility. It is also a moral responsibility. That too has been incorporated in our law. And yet we have seen chronic underfunding of Indian Health Service, the federal agency that provides direct health services, and chronic underfunding of Indian health programming in general. And it has always been the case in that regard, but COVID-19 has really magnified just how underfunded these programs are in terms of many IHS facilities. Just a few weeks after most jurisdictions had implemented some sort of shutdown in March, are running out of personal protective equipment for healthcare, already don't have enough healthcare providers, enough ventilators. We have seen instances of the federal government supposedly distributing personal protective equipment to Indian health facilities and instead sending body bags. And so that is just, frankly, a chronic foundational issue that has also led to other issues. For example, inadequate access to public health data. I argue that federal law and treaties require that the federal government, including IHS and the CDC, to provide public health data to tribes, and they are required by statute to provide that data to tribal epidemiology centers. And yet, we are seeing that IHS facilities not providing data to tribes, CDC significantly delayed in providing data to tribal epicenters, and that makes it very difficult, if not impossible, to craft effective policy and strategy and investment in certain areas. We have unfortunately seen seafood and water insecurity in certain parts of Indian country, of course not all, and there is absolutely federal underpinnings in terms of water access, in terms of access and use of land, environmental conditions. I wish we had all day to talk about some of these issues, but they are there, and it's so essential when we're responding to a pandemic like COVID that there is going to be access to clean water. We are expecting folks to stay at home, but food insecurity is a big problem in a lot of communities. And so, not to mention broadband access and so much more. And so it is not hard, besides explicit references to protecting water rights or having access to food in various treaties. This is part of the federal healthcare requirement to American Indians, Alaska Natives, and yet over and over again, we're seeing that that is not being met. The federal government, through a series of executive orders, and frankly, as an extension of the trust responsibility that the federal government has to tribes and American Indians, Alaska Natives, are required to consult with tribes when they are taking action that's going to impact tribes and tribal communities. And yet, for anyone who has had any experience in observing consultation sessions between tribes and the federal government, they have been grossly inadequate. And oftentimes, the federal government is letting tribes know after the fact that they made a decision, what their decision was, without any meaningful consultation. And in the context of making decisions in terms of personal protective equipment, medical countermeasures, data access, those are all things that tribes have a right by law to have a say in. And just another example, but I can keep going, Special Diabetes Program for Indians has been continuously at risk of lapse of funding. We know that folks with diabetes are more likely to have worse health outcomes if they get a COVID-19 infection, and yet this highly successful program that funds over 500 tribal programs is always at the brink of losing funding. It doesn't make sense, and it violates the law as far as I'm concerned. And I could go on. So what are the other considerations that we have to think about? Well, although tribes are sovereign nations, they are often located in what is now considered states within those boundaries. And so this raises a variety of jurisdictional issues and provision of public health services because of interpretations of frankly made up and racist federal Indian policies from the 1800s. These have left tribes with very limited jurisdiction over non-members, even within the outer boundaries of the reservation. And that is incredibly problematic if you have non-members coming into your lands, even when they are not allowed, and engaging in conduct that can be risky in terms of gathering in groups, not wearing masks. And having tribes, and the areas where tribes do potentially have the authority to extend non-member jurisdiction, federal courts have not been very likely to extend it. And we've also had issues, although states and local governments have very, very limited jurisdiction within the boundaries of the reservation, state and local governments not honoring that. And that is incredibly problematic because it interferes with tribal responses. And been a lot of instances where states have opted not to provide a comprehensive COVID-19 response, tribes have stepped up to protect their communities, and having it interfered with by their neighbors is incredibly problematic. There are tools that are available under the law to support intergovernmental coordination, cross-jurisdictional agreements, MOUs, data sharing agreements. But of course, it's always better to have those prepped in advance and knowing what circumstances they apply, but it is not too late to establish processes. And for folks that represent or serve tribes, I would just suggest making sure you've got open communication with your tribal attorneys, because you never want these agreements to interfere with tribal sovereignty or undermine tribal sovereignty in any way, which can certainly be a possibility. And to just dispel the rumor that, you know, tribes always need help from the state and local governments, that's just not accurate. Some tribal infrastructures, because of tribally led interventions and investments in healthcare and facilities, have a more comprehensive and robust public health system, and that could be of service to their neighbors. And many tribal emergency management plans contemplate being good neighbors, and that is part of the culture and community that we see in tribal communities. And so there's a benefit to everyone when we make these plans in advance. And to reiterate, in the context of tribal resiliency, they can mitigate some of the gaps that we're seeing under federal law, but you can't completely eliminate them in some instances. And so some considerations tribes may consider as being a tool is developing new public health processes, understanding that the government structures for many tribes are a result of federal interference in internal government affairs, and that it is not always best to write everything down, but this might be an opportunity where things could be written down. And so that can include designating certain departments as public health authority, designating certain positions as a public health officer. And while I will, till the day I die, argue that tribal inherent authority doesn't necessitate their doing these things in order to be the government public health authority, it can facilitate easier communication and resource sharing and data sharing between state and local partners who just don't understand or respect tribal sovereignty. It's a shame that tribes are going to have to do all of that, but again, in the kind of pandemic situation we are, that could be particularly useful. I would love to say more about intra-governmental considerations with the tribe. So how does tribal council relate to tribal health agencies or social service agencies that may be decentralized in health situations? How do we relate to health clinics, even those that are 638'd and tribally run, when they're often run by non-native, non-tribal member physicians? And what does that look like when we're doing government functions like contact tracing, et cetera? And that is to say, in some ways, these are unprecedented, and there could be issues in terms of potentially undermining tribal sovereignty. All the more reason to start thinking about them as soon as possible. So our chapter on tribal health in the report raises a variety of recommendations. I don't have time to talk about them all. I want to reemphasize tribes potentially implementing codes and writing down processes in advance. But in the context of the federal government, honor your trust, responsibility, and consultation requirements. IHS, CDC, give data early and stop making tribes jump through hoops to get it. And for state and local governments, I know it's really hard because there are sovereign nations within your boundaries, but that does not mean that you have jurisdiction on tribal lands. And there are much better cooperative ways to be a good partner than to be going on tribal lands when you don't have the authority to do so, or engaging in tribal government functions. So respect tribal authority, talk to tribes on how you can be a good partner. This report is going to get updated and republished, and it is incredibly important that tribes, tribal serving organization, tribal communities, and their partners have a voice in this. And so we are very much welcome any suggestions or comments that you might have. And the link to the report is right here, but you're also welcome to contact us directly. So with that, I'm excited to dig into a couple of questions while we have a few minutes.
Yeah, it looks like there's a couple. First one was, are there any states that have invested in tribal health to address the federal gap? So I encourage you read our chapter section, because it provides more background on the way health services are provided to Native people in this country, right? We generally call it the ITU system, IHS through the federal government, T for tribes. When you heard the term 638, they can kind of get the funds, manage it themselves, and then U for urban. It's roughly 50% of Native Americans live in urban settings. And it was a really big deal for urban Indian centers, which are nonprofits, like here in Utah, we have the Urban Indian Center of Salt Lake. They got CARES Act money. And so states don't really they're not really going to play a big role on reservation lands. Isla can talk kind of maybe about the data, because they will do agreements to share data. And in Utah has done that with the tribes here so that they can share data about COVID numbers. But otherwise, states are going to be more focused on their urban Indian populations, natives that reside off the reservation on lands that the states would control. And so again, Utah, our Department of Health, has a tribal liaison person and someone who looks at the native population in our urban centers. But otherwise, states, I think it's a much more limited role. I don't know, Isla, if you want to add to that, and then there's a data question, I think.
Sure, yeah, so, it's important to remember that a tribal member is also going to be a citizen of the United States and a citizen of the state. And so they are going to be entitled and need to be served just like any other citizen of the state. And so there are absolutely state programs that seek to support American Indians, Alaska Natives, and within their boundaries. You might see examples of state Medicaid policies, for example, waiving fees that might end up for any folks that are receiving benefits that might be American Indians, Alaska Natives. Some of that's trickling down from some of the federal policies related to that. We have states that have tribal liaisons and tribal health offices, American Indian and Alaska Native health offices within their health departments, and focus on serving as a liaison, collecting data, doing targeted programming, and ideally, fingers crossed, that is all with consultation with tribes that they may be working with. So there was also a question about a model data use agreement. I always kind of get nervous about having model agreements in the context of tribes because some of those issues can be really tribe to tribe specific. And we would not want there to be instances of undermining tribal authority in any way. But the American Indian Health Center of Washington has put together an incredible COVID-19 page that has a bunch of language in terms of tribal code language. They've been involved in intergovernmental agreements involving tribes, and so that might be a good place to start. And then I see one more data question, and it might be the last question we have time on, about how do data sharing processes work with the change of tribal epicenter. So with the ACA in 2010, it also permanently reauthorized the Indian Healthcare Improvement Act, which does a variety of things, including designating tribes as public health authorities under HIPAA. So when we're talking about in the context of health information. So I think that is first an important piece, that it is a designation that's only under HIPAA, and it allows for techs to receive public health data because of the HIPAA exception to be able to access private health information between public health authorities like a state department of health, a federal agency, a local health department. So it puts tribes in that bucket of being able to access and receive that data. And that has been a barrier, and unfortunately continues to be a barrier for reasons why state and local partners have opted not to provide data to even tribes, but also tribal epicenters. And so that reauthorization and that statute, that particular provision, also requires that the HHS, the Department of Health and Human Services, and CDC provide that data. So this is something that techs should be able to get their data, and when they don't, it's because folks are violating federal law, and that's plain and simple. I think I'm going to get in trouble. Charles, we're probably out of time, huh?
Yes, we are. So I'm sorry to cut you both off, but if anyone has any additional questions, you can either shoot one of our presenters an email or a message straight into Pathable. With that, thank you all for attending today's session. If you have time, please just take a minute to fill out the evaluation for this session by scrolling to the bottom of your screen in Pathable. And that's it. Have a great rest of your day. Thank you, everyone.